Hello, my name's Colin Bennett. I'm here today to talk to Neil Thomas and Jonathan Mansfield from the employment law specialist firm of solicitors, Thomas Mansfield LLP. In this programme, we're going to see a case study of an employer putting in place an arrangement to inform and consult the workforce through representatives. So, Neil, what is the purpose of the Information and Consultation Regulation?
Well, they arise out of a European Community Directive on information and consultation in the workplace. They are to bring the UK in line with other European countries who've had consultation structures in place for many years. The regulations could affect many organisations who do not currently consult with their employees on a formal basis, whether through trade union or non-trade union representatives.
Does that mean that employers will have to recognise unions?
No, that is covered by different legislation. These regulations provide a framework for employers to inform and consult with their employees on certain issues through representatives.
So what do you mean by consultation?
Well, consultation means asking employees' opinions and giving them consideration before making decisions. It will still be management's prerogative to make decisions and run the company.
So what's in it for the businesses?
A good communication may lead to a more effective and productive business. Business benefits from clearer lines of communication, and that can be brought about by developing a culture where employees can express their opinion on matters before any decision is made, so they feel as if they are actively contributing to business decisions.
Does the law specify how an employer must consult the workforce?
Well, in fact, the law allows employers and employees flexibility. They may decide whether to keep in place an existing arrangement or negotiate a new agreement. An employer could instigate negotiations, or employees could make a request under legislation. If the negotiations fail, a fallback scheme is imposed. Alternatively, if the employees do not wish to have an arrangement, no action needs to be taken.
This is the company we'll be studying, Planet Electrical, a company with some 480 employees and 2 subsidiaries with 30 and 40 employees respectively. They've been manufacturing and selling electrical components for more than 60 years. The 2 subsidiaries are a software development house and the other is an importer and distributor of electrical cables. There is a history of distrust in the company. There's no union, there's no formal or informal agreement in place to discuss issues with the workforce. A telephone call has come in from the accountants acting on behalf of Galaxy, a major competitor based in the US. Planet have been given the opportunity to make an offer for the business. No other competitors have been notified and Planet would be subject to a non-disclosure agreement. It's very important for both parties to maintain confidentiality.
Hey, T-boy, what are you doing here so late?
We've got a board meeting.
All right. On your way then.
Okay. Oh, thanks. Sorry, we didn't have any crisps.
Now, the reason we need to get together tonight is to talk about the bid we intend to make for Galaxy. Now, this will provide terrific opportunities for us. As well as gaining instant market share, it should mean better margins.
Provided the deal goes through, it looks as if Galaxy will agree to our developing R&D here, with a view to bringing their people over eventually. And we should be looking at cost savings in approximately a year. What I can't emphasise strongly enough is how super sensitive the talks are at this stage. We can't risk even a hint of this getting out.
Helen, any comments from an HR perspective?
I appreciate John's concerns, but I do really think it's important to think about how and when we let people know. We need to manage the process rather than just keeping people in the dark. We can't just wait for the inevitable leaks and rumours. They're bound to jump to the wrong conclusions.
For heaven's sake, Helen, you'll be telling me next we're setting up works councils and inviting Robbo What's-his-name in for tea and sandwiches.
Well, as a matter of fact, like it or not, there are some European regulations which say that we might have to communicate with our workforce about things just like this. The Information and Consultation regulations allow the workforce to appoint representatives to discuss issues with managers affecting the business. It could be useful to us.
You can talk Eurospeak to me till the cows come home. If you ask me, we've survived in spite of Brussels, not because of it.
OK, John, look, Helen is just saying that we need to manage how the news gets out better than we did last time when we were dealing with redundancies. Now, let's not shout about this from the rooftops at this delicate stage. I mean, we're not talking about job cuts.
Job cuts, is it?
There was a management meeting here last night, once everyone had gone home.
How do you know that?
I was here. I had to come back to get my coat.
Who was at the meeting?
The whole lot of them. They were talking about more job cuts.
You are joking, not again.
Are you sure, Joe?
I heard them. I heard the words redundancies and job cuts.
Yeah, well, I've had enough. The next thing you know, that Helen Cleverdick of the management will be telling us to get on our bikes. While they get their bonuses and their flashy cars, we get put on the dole.
Mr. Robert Redburn to see you, David.
Why do they call him Red Rob? Oh.
Because I'm furious.
It's all right, Joyce, I can see why.
Right. Word on the shop floor has it that job cuts are on the line again.
Oh, it's the first I've heard of it.
No, don't give me that. Anyway, if you won't tell me now, you'll soon have to. The information and consultation regulations.
I appreciate that, but what is this about job cuts?
The regulations say that you've got to talk to us. The time has come for open dialogue and to let us have a say in running the business. Before I came to Planet, I spent 18 years as a T&G assistant branch secretary.
Hold your horses for a minute, Robbo. I've got no intention of keeping you in the dark. There are no job cuts. Robbo's just told me he's heard there's going to be job cuts. Where'd you get that from?
Well, I don't know. He can't have heard anything anyway, can he?
He started on about the information and consultation regulations, his days as a union rep.
What's all this about unions? Is it Robbo again? When he's excited, he always harks back to his days as a union rep.
All right, don't panic. The information and consultation regulations do allow for representation of employees. Robbo hasn't made a valid request yet.
It's the EU again, isn't it? I tell you, he'll be running this business over my dead body.
There's no question about Robbo running the business. The regulations are only about informing and consulting. They're important because of our size. Anyway, we can't just ignore them. In fact, we might get our own terms rather than being forced into them if we were to actually negotiate. If we take the initiative ourselves and involve people, we might get more mileage out of the arrangements.
Well, she's got a point. Helen, can you prepare a briefing paper for us on exactly what the regulations say? Then we can think about how best to take the next step forward.
Sorry, there aren't any crisps.
Helen?
David has asked me to do a bit of digging around on the information and consultation regulations, as they do affect a company our size. Now, it will take a few moments, but it's all vital stuff. John, would you mind? Thanks. First of all, I'll talk about who the regulations apply to. Then I'll talk about the different possibilities for complying with them within the workplace. The first thing that has to be said is that the regulations apply to either public or private undertakings, carrying on any economic activity. This means they apply to us as well as public sector organisations.
Yes, well, let's just stick to people like us, shall we?
Our satellite subsidiaries in Gillingham and Norwich will not actually come into this because they have less than 50 employees at each location. Incidentally, these are the enforcement dates. Before I go on to talk about exactly how a compulsory arrangement could be put into place, I just wanted to mention the 3 different ways that the arrangements can apply to a company. The first possibility is that you have a pre-existing arrangement. Now, this is something which would apply if, say, we recognised a union, which, as you know, we don't. To be valid, such a pre-existing agreement must be in writing, cover all the employees of the undertaking, set out how the employer is to give information to the employees or representatives, and seek their views, and must have been approved by the majority of the employees through a ballot or signed acceptance. Now, if a 10% request is received under the new procedures and there is a pre-existing agreement, the employer either has to initiate negotiations or ballot the employees as to continue with a pre-existing arrangement. If more than 40% of the workforce make the request, the employer will have to start negotiating a new arrangement. If the majority of those voting or 40% of the workforce vote in favour of the request, Negotiations for a statutory information and consultation arrangement must begin.
Yes, but what about us?
The second one is the negotiated arrangement. This occurs following an employee request or overturning a pre-existing arrangement and then agreeing to negotiate with the employees in question. The third possibility is the statutory arrangement, which would take place if we could not reach any agreement with the employees, or we are not prepared to negotiate with them. Of course, if no valid request is made, then nothing at all needs to happen to comply with these regulations. In addition to the above scenarios, there is the possibility of a voluntary arrangement outside the regulations, or no arrangement at all. Is everybody clear? Perhaps I'll summarise. Now, there are two ways negotiations can be opened to establish statutory information and consultation.
So now it's negotiations about negotiations.
Well, that's probably about right, actually. There are really two stages to the whole process once a valid request is made, or the employer agrees voluntarily to set up a statutory arrangement. Firstly, there are discussions with representatives chosen to negotiate the form and content of information and consultation arrangements. Secondly, there is the arrangement itself, which can either be negotiated one or, in the absence of agreement within 6 months, or a mutually agreed extension, a standard procedure will apply. Thanks, John. Any questions?
Yes. Would anyone like a tea?
There are some more details available in documentation, but those are the things we need to think about for the moment.
Well, thanks very much, Helen. So where do we go from here?
I think the best thing for us to do is to actually take the initiative on this one.
So we've got to tell Red Robbo and the workforce everything we're planning to do. What about confidentiality? If a word of this gets out, the whole deal will be lost.
I have to say I'm with John on this one. I mean, there is a danger of information going public. I've got no problem with talking to people who genuinely represent the workforce, but I don't see why we should be rushed into anything at this stage. Why don't we just wait and see?
At last, a bit of sanity.
Right. You know why I'm here, don't you? These new regulations. I am within my rights to start getting the ball rolling on this. You seem to be dragging your feet. Ask Helen Clever. I can write a letter to the Central Arbitration Committee unless you turn around and do something.
Yes, there is legislation that provides for giving information to and consulting with representatives if that's what employees within the workforce want. Now, my understanding is that you should check out the regulations and produce a valid application, and I'll of course consider it. But at this stage, there's no valid application on the table.
Yeah. Well, I'll be back. I know where I stand on this.
Look, I've been reading this stuff that Robbo's been going on about. What it says here is that to put in a valid request under the procedure, we need to have the support of 10% of the workforce, or not fewer than 15 or more than 2,500, but I don't think that applies to us. We've got to put the request in writing, stating the date which it is sent, and that it is a formal application under the procedure. This has got to go to the head office or principal place of business of the employer. Do you think we'll get that many? You know what they're like. People don't want to stick their necks out, or they just won't take it seriously.
Yeah, I think you're right to worry.
Well, actually, there's an answer to this problem. We don't have to put the application into our employer directly ourselves. What we can do is send it directly to the Central Arbitration Committee. It can go anonymously. If we put it around there's not going to be any comeback, then people will sign it, especially with these rumours about job cuts. Well, I've been getting absolutely nowhere trying to get the information from the various departments about the exact number of people we need for this request. We need to get 10% of the workforce. We're doing pretty well. We've got about 7%, but that's probably not enough. We need to find out exactly how many people on average over the last year have been working here. It might not be as many as we think.
What about summer placements? Do they count?
No, we only count our own employees, not agency staff or contractors. We have to take the average over the year and only from the main company.
Okay, well how do we get the exact numbers?
Well, I've written a letter requesting the numbers. It says here that an employee or an employee's representative may request data from the employer for the purpose of determining the number of people employed by their undertaking in the United Kingdom. That means they've got to tell us how many people are here, or we can make an application to the Central Arbitration Committee. I've already written it, see if it's okay. Dear David, I am writing further to the Information and Consultation Regulations to request that you provide details of the number of employees within the company on average over the past 12 months. If you do not provide this information, we will be forced to go to the Central Arbitration Committee to request that they order you that you provide this information. I look forward to hearing from you.
So, now what?
Tell them the numbers.
Oh, why make it any easier for them?
I want to, but I'm worried about letting out confidential information during the discussions.
But if you make it more awkward, you'll only get their backs up. Negotiations will be a nightmare. Experience has shown in other companies that it won't be if you just trust the employees.
Okay. Let's disclose the numbers. Let's agree to give them up so that we can start negotiations for setting up the process to facilitate a negotiated consultation agreement. Helen, will you take the lead on this?
Oh, Sally, here are the figures by department, which also include the employees on maternity leave and long-term sick leave. They should help you to determine whether you can obtain sufficient support to appoint representatives and who they're going to be.
Thanks.
If you need anything else, let me know.
I will do. The next stage is to draw up a list of names and then find out who's interested. Good luck. Well, we've got it. I make that 49 signatures.
Well, that's our 10%. We've done it.
Yeah.
An employee request will now start a timetable for a number of issues. 3 months for an employer to initiate negotiations to set up an information and consultation arrangement. 1 month to inform employees if they are to be balloted on continuing with a pre-existing agreement. 1 month for an employer to contest an employee request. 3 years during which no further requests can be made if the employees do not endorse the request, and 6 months before the standard information and consultation provisions apply if no agreement is reached.
The categories we are proposing are that manufacturing should have 2 representatives, distribution should have 1 representative, and administration should have 1.
No, I disagree. This is what we've come up with. There must be 1 representative from each of the following departments. In manufacturing, stores, assembly and packaging. And in distribution, there should be representatives from the dispatch office, drivers and the warehouse. Finally, in administration, we should have representatives from sales and marketing and from the accounts department. So in total, the employees require 8 representatives.
That's far too many.
So, Jonathan, what rights do individual representatives have in this process?
Firstly, representatives have the right to take reasonable time off to perform the functions of a representative. In addition, the representative has a right not to be dismissed for performing his or her functions as a representative or seeking to be paid for time off to perform his or her functions. And note in this case that the 1-year qualifying period for unfair dismissal will not apply. Thirdly, there is protection against detriment in the form of actions short of dismissal for the same reasons.
I'd like to give you an update on the bid. The shareholders have been informed of the offer and they're willing to provide the necessary funds to buy Galaxy. So now we're going through the process of due diligence. No skeletons yet been discovered in the cupboard. Right, item number 4 on the agenda. Helen, you were going to tell us about the proposals for the information and consultation agreement.
Yes, thank you. Firstly, we're proposing meetings be held quarterly.
Oh, why quarterly?
Because regular and clear communication will benefit us, especially with things happening so quickly. On the management side, we have John, Steve and myself, and the representatives that have now been appointed are Sally from sales, Joe from manufacturing, Mo from distribution and Robbo from manufacturing.
What about me? Aren't I playing a part?
Sorry, no. The group's normally involved operations managers. But we would like you to be at the first meeting.
And what are we going to be talking about at this meeting?
Information on the recent and future development of our business activities and our financial situation. Information on the structure and development of employment within the business, and in particular where there is a threat to employment within the business, such as a takeover. And finally, information on decisions likely to lead to substantial job losses or changes in contractual relations.
So now I'm going to be negotiating Robbo's pay rates and tea breaks.
No, of course not. We might agree as part of the process to consult with individuals on certain issues, as long as we don't undermine the representatives. I was also planning to suggest a questionnaire so that we could get some opinions from employees on certain issues.
So now the contents of the negotiations are up for negotiation.
Well, we are entering a difficult part.
Negotiations over the contents of the agreement may last for up to 6 months, though this period is extendable without limits by agreements between the employer and the majority of the negotiating representatives. The regulations do not set out detailed rules on the content of any negotiated arrangements. The aim is to let the parties determine the best structure for themselves, but there are basic minimum requirements. In order for it to be a valid negotiated agreement, it must, firstly, set out the circumstances in which employers will inform and consult with their employees. Employers and employees are given freedom to agree on the subject matter, method, frequency and timing of information consultation. Secondly, provide either for the appointment or election of representatives or for information consultation directly with employees or both. Thirdly, be in writing and dated. Fourthly, cover all the employees of the undertaking or group of undertakings if more than one undertaking is to be covered. Different arrangements and different parts of the undertaking may be agreed. The separate arrangements may be entirely different from each other, but between them they must cover all the employees of the undertaking. Also, it must be signed by or on behalf of the employer. Finally, it must be approved by the employees. The regulations provide that it must either be signed by all the negotiating representatives or be signed by a majority of the negotiating representatives and be either approved in writing by at least 50% of the employees of the undertaking or group of undertakings, or approved by 50% of employees that vote in a ballot. In the event that negotiations fail between the employer and the representatives to reach an agreement within 6 months, or the employer fails to initiate negotiations in light of a valid 10% request, or a successful ballot against a pre-existing agreement, then the standard procedures apply effectively by default.
I'd like to open this meeting by welcoming everybody, and I'd like to introduce everyone. Steve has agreed to take notes, and it's been agreed that the minutes will be circulated after each meeting for agreement in advance of the next meeting.
Has anyone got a pen?
The aim of this meeting is to reach agreement on the arrangements and areas for consultation.
The first thing we need to discuss is job cuts.
And new rates of pay, that's
Health
my...
and safety, I think, is quite important.
No, I think job cuts before anything else, as I explained to you before, I think job cuts first.
I would like now to summarise the points that I think we are all agreed on to provide a framework for the information and consultation arrangements looking into the future. At the very start of the process, we would organise training sessions jointly for both employees and management representatives. Now for the agreement itself. Firstly, management will present a quarterly financial report. We've also agreed that this forum will be used in the unfortunate event of redundancies arising, or if there is a transfer of the business or an acquisition which is affected by the Transfer of Undertaking Regulations, or TUPE. We have agreed, however, that we will put in place a mechanism for resolving disputes over whether information is confidential. If you disagree, we should jointly ask ACAS to conciliate between us, and if agreement cannot be reached within 21 days or a further period if mutually agreed, then you may exercise your right to apply to the Central Arbitration Committee for adjudication on the matter. We have also provided for a review of the agreement after a year. Finally, it has been agreed that while consultations will be carried on with a view to reaching agreement, this forum will not make decisions which are binding on the company. Of course, a copy of the written agreement will be included in the handbook and published on the intranet.
So that's all agreed.
Sorry, did you want me to write any of that down? Thank you.
Look, we can't afford to let our competitors know about our offer for Galaxy. We're the only company being given the opportunity to bid. If a word of this deal gets out, the whole thing will be lost.
There are already rumours around on the shop floor. If we tell the representatives and ask them to keep it confidential, it would show willingness on our part to trust them. And after all, it's good news we're going to be telling them.
But we don't even know who these representatives are going to be.
This is a nightmare. On the one hand, I don't want the deal to fall through, and on the other hand, there's confidentiality.
Well, I might be able to put your mind at ease about that.
So whether or not to tell the employees must be a typical dilemma, but what are the consequences?
There are two main options. Firstly, tell the representatives. That might be commercially disastrous if they leak out confidential information. Secondly, tell the representatives and place them under an obligation of confidentiality. If they let the cat out of the bag, there will be a breach of a statutory duty. In the film, Planet may restrict information given to representatives if it is in the legitimate interests of the business.
What is the effect of the employer placing a confidentiality restriction?
Then there's a statutory duty on the representatives not to disclose the information. It is important for the employer to make clear when providing documents or information whether there is a confidentiality restriction and its extent, if any. In addition, employers may consider a contractual confidentiality agreement which might continue after the end of the period of office of the representative.
Can the recipient of confidential information challenge this?
Yes. The regulations allow for an application to be made to the Central Arbitration Committee for a declaration as to whether a requirement to maintain confidentiality is reasonable.
Are there any circumstances in which information may not be disclosed to the employee's representatives?
Yes, if it would seriously harm the functioning of the business or be prejudicial to it. The DTI guidance suggests that evidence of past leaks could be a deciding factor.
I'd like to welcome the representatives to the first information and consultation meeting, in which we're going to set out the financial situation and talk about the market and the plans and prospects for the company. But before I do, I need to hand over to David.
Well, thank you all for coming. Now, I want these meetings to be as productive as possible for everyone. The first item we should be discussing is something which is of great significance for the business, but it's also something which is of great commercial sensitivity. I've got to stress that the effect of information getting out at this stage could be detrimental to everyone's livelihoods in the company. I understand that you're setting up a confidentiality agreement.
Yes, we have discussed the issue and everybody here has confirmed their acceptance of the agreement. What David is going to tell you now must remain within these four walls.
How can we agree to that if we don't even know what you're going to tell us?
Robbo, when you hear what the information is, you will understand fully that it is highly commercially sensitive, but you will also remember we have a mechanism for resolving any disputes about the issue of confidentiality. What we need from you now is confirmation of your commitment that pending your agreement, you will accept the confidentiality of this information.
We agree to keep the information you give us confidential.
And what I have to report is that we are on the verge of signing an agreement with Galaxy. Now, the effect of this is that the livelihoods of all the employees in Planet are likely to be safeguarded. It's a significant step forward for the company. It gives us the opportunity to get into other markets where Galaxy had already got a foothold. There will, of course, be some ramifications for the way the company is organised somewhere down the line. But I firmly believe that we'll be able to achieve this restructuring with no job losses. Indeed, there's a significant possibility of recruitment at this location and in our 2 existing subsidiaries. Now, the reason that this information is so sensitive is because we haven't yet signed the deal. Now, we're hoping to do this within the next couple of weeks, but for that reason, I'm putting a moratorium on any announcement being made before an announcement comes from the company. Rest assured, you'll be the first to know. Indeed, we'll be pleased for you to take this information back to the workforce once the announcement is made public.
So what approach should employers take to the regulation?
Well, it is advisable to have a strategy in place for dealing with the issue firstly. And then employers need to consider whether they believe the arrangements will indeed add value to their organisation. Some employers may feel that it will benefit employee motivation by promoting trust and also engagement in the development of the business. It may also be seen as a potentially useful tool for managing change. There are other benefits. One is stability, because once in place the arrangement cannot be challenged for another 3 years. And in addition, under a statutory scheme, there are additional protections in respect of confidentiality. Other employers may be less convinced, of course, of the business value of the arrangements, but nonetheless see an employee request as likely. In such a case, it may be that the employer will still wish to initiate either a pre-existing arrangement outside the regulations or to start the process of setting up a statutory scheme. By taking the initiative, they may achieve more control over the process. If the employer does take the initiative, it does not mean that there is a need to rush into it, as it is important that an agreement is reached which suits the needs of the business, as it will be in place for some time. In some cases, the employer may assess that employees are unlikely to make a request and that a formal arrangement complying with the statutory criteria will have no benefit for their business. Alternatively, an arrangement not fulfilling statutory requirements may already be in place or negotiated as an alternative. Even in such a case, it is important for the employer to be aware of the possibility and likelihood that the situation will change as such arrangements may become more widespread.
Hey, I hear they're not talking about job cuts.
No, the MD says our job's actually going to be much safer.
Yeah, that's what they're saying.
So our jobs are actually safe.
Yeah, that's right. Thanks to me.
Great. Cup of tea then, eh?